that she was busy, my lord, in the proceedings before the Honorable Supreme Court. Therefore, my lord, she was not able to.
My lords, may I submit, my lords? I need to address these submissions. My lords, what had happened is, under the SFC has initiated Section 29 proceedings, which went all the way up to the Supreme Court, my lord. And the SFC proceedings were initiated and the property of the appellant was sold without even a notice to her. And that was the reason that she had to challenge the action taken under those proceedings. It was challenged by way of writ petition, and finally in the writ appeal, the sale of the property was set aside, my lord. And the respondents did not stop at that. All the way to the Supreme Court, she was made to litigate, which finally reached its finality, my lords, in 2017. She's a senior citizen. She lost her earning son in a very young child was lost in tragic circumstances, and she is being pulled from one court to another at the hands of the respondent, and she is also facing litigation in an eviction suit because her tenants, because sorry, my lord.
We'll secure the records, madam, then we will consider your case.
Please, my lords, I'm much obliged.
Referring to some document, let us see what is the document.
Please, my lord.
This matter in the first week of March.
May I request for a date, my lords?
It will be listed in the first week of March.
Much obliged.
In this case, I prefer the respondent. I pray for 2 weeks time to file objections to the application, my lord.
It's a matter week after next with the request of the learned counsel appearing for the respondent.
My lord, I appear for the appellants. My lord, there is a delay of 160 days delay in filing this appeal against the order of the ESI court. My lord, the respondent is covered by the under the ESI Act, but they failed to pay certain contributions, and therefore we had initiated the proceedings. My lord, according to them, the APMC are governed under the government rules, so therefore they are not likely to be covered.
Notice, madam. Emergency notice.
Please, my lord.
Betty Rasheka. High Court Report Officer.
My lord, court is not audible, my lord. In the serial number 21, I am appealing for the appellant, my lord.
Lord, serial number 21.
My lord, serial number 21, I am appealing for the appellant, my lord.
My lords, court seems to have logged out, my lords, unable to hear the proceedings.
Only that unfortunately the RTC produced by the current at page 645 is Whistler has come to the original license facts. Whistler also signed a memo. Last paragraph of my memo, 19.
I made my submission, my lord. I am for the appellant, my lord.
Yes, kindly make your submission, sir.
My lord, the memo which I served yesterday evening, my lord, I got through the memo, my lord. In that said memo, my lord, they produced that the RTC in their 1996, 97, they are not produced, my lord. Because the 94, 95, 95, 96, that is the second RTC, my lord. May kindly see the second RTC, my lord. That is there 94, 95, 95, 96. And there is no 96, 97, my lord. In the 96, 97, in the column number 12, my lord, it is rounded to the Munikempaya and entered HV Ramakrishnappa. HV Ramakrishnappa is the appellant, my lord. And next RTC, my lord, it is 97, 98, but there is no 96, 97 RTC, my lord, which I produced the 96, 97 RTC in page number 645.
No, what about the RTC related? 96, 97.
96. That's what I take this RTC 645. What he has produced, this is because overwriting he has done on his own. This is tampering on the I believe there are 500 affidavit. It's not direct from that. It's rounding and writing the name. They would not have done it.
My lord, page number, page number 642, MR number 13 and MR number 14, my lord.
Where is the RTC?
645.
645.
Yes. Earlier, what I have produced is the book. RTC original which is there. After that, they will take in the form and they will fill and give it. There is a method not knows that. If the name is not there, which is they would not have 645. This Lord says some code has been out for that.
My lord, page number 645, my lord, in column number 9, my lord, it is rounded to the Channamma and Munikampaya, my lord. Then it is entered HV Ramakrishnappa. Second value, madam.
RTC number? Page number 37. This Chennamma is there, but M.E. Ramakrishnappa is not there.
appellants. Regulars our say, all these RTC returns that they may never entered in RTC for any case. It should be regulars with the deal and companies. 226 is not.
May I permit to submit, madam?
Sir,
May I permit to submit, my lord?
yes, kindly make your submissions.
My lord, in the second RTC, my lord, which my learned friend, government advocate said that in the second RTC, which produced by the memo, my lord, it is there. 94-95 Munikempaya, 95-96 Munikempaya, and Munikempaya rounded off, my lord. Munikempaya rounded off, and HV Ramakrishnappa entered. That is in the MR page number 642, my lord. Page number 642, mutation, my lord. Mutation register. Page number 642, mutation register. On the basis of the mutation, it is rounded off and entered the name of the appellant, my lord, in the RTC which produced by the government advocate, my lord. That
Yes.
mutations are certified with the Tahsildar, my lord, which I produced along with the additional documents, certified and issued to the appellant. That certified copies which I produced before this honorable court, my lord, which is certified by the Tahsildar, my lord. Page number 639, first mutation, and page number 642, second mutation. MR number 13 and 14, my lord. And thereafter 645 is the RTC. Now the presently along with memo 96-97 RTC, they are not produced. Now it is very clearly shows that 94-95, 95-96, and in the next page 97-98, and there is no 96-97 RTC, my lord. That is 96-97 RTC, which I produced along with the appeal memo. That is page number 645, my lord. Even I have one more copy, certified copy, my lord. I may kindly permit to file in the counter, my lord. I will file along with memo, my lord. One more certified copy is with me, and I also applied in the same copies to the Tahsildar in the certified copy of the mutation and RTC 96-97, which permit me to produce before the court, my lord. Also, MRs all certified copies, my lord, which I produced along with my appeal memo, certified by the competent competent Tahsildar office.
Why you have produced only one?
My lord?
96.
My lord,
Why you have produced only one artist of the year 96-97? What happened subsequently?
My lord, subsequently ಕೈ ಬರಹದ ಆರ್ಟಿಸಿಗಳು 13 MR ನಂಬರ್ 14 ಆದ್ಮೇಲೆ 96-97 ಕೈ ಬರಹ ಆರ್ಟಿಸಿಗಳು ಬಂದ ಮೇಲೆ ಸ್ವಾಮಿ ಅದೇನಾಗುತ್ತೆ, ನಮ್ಮ ಹೆಸರೇ ರಿಮೂವ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಆಗ ನಮ್ಮ ಹೆಸರು ರಿಮೂವ್ ಮಾಡಿದ್ಮೇಲೆ ನಮ್ದು ಹೆಸರು ಬರಲ್ಲ. ಅದು 2000 ಇಸ್ವಿಯಿಂದ ಕಂಪ್ಯೂಟರ್ ಆರ್ಟಿಸಿ ಬರುತ್ತೆ ಸ್ವಾಮಿ. ಕಂಪ್ಯೂಟರ್ ಆರ್ಟಿಸಿ ಬಂದಾಗ ನಮ್ಮ ಹೆಸರು ಬರೋದಿಲ್ಲ 2000 ಇಸ್ವಿಯಿಂದ. ಆಮೇಲೆ ನಾವು ವೆರಿಫೈ ಮಾಡಿದಾಗ ಗೊತ್ತಾಗುತ್ತೆ ನಮ್ಗೆ ಸೇಲ್ ಡೀಡ್ ಆಗಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೆಸರಿಗೆ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಅಂತ ಸ್ವಾಮಿ. ಕೈ ಬರಹ ಆರ್ಟಿಸಿ 2000 ವರೆಗೂ ಕೈ ಬರದ ಆರ್ಟಿಸಿ ಬರುತ್ತೆ ಸ್ವಾಮಿ. ನಮ್ದು ಮುಟೇಶನ್ ಆದ್ಮೇಲೆ ನಮ್ಮ ಹೆಸರಿಗೆ ಆರ್ಟಿಸಿ ಬಂತು, ಕಾಲಂ ನಂಬರ್ 9 ಮತ್ತೆ ಕಾಲಂ ನಂಬರ್ 12 ಅಲ್ಲಿ ನಮ್ದು ಬಂದ ಆದ್ಮೇಲೆ ನಾವು ನೋಡ್ಕೊಂಡಿದ್ದೀರಾ ಅದನ್ನ ನಮ್ದು ಕೈ ಬರಹ ಆರ್ಟಿಸಿ ಬಿಟ್ಟೋದ್ಮೇಲೆ ಅವ್ರ ಹೆಸರು ನಮ್ ವೆಂಡರ್ ಹೆಸರು ಕಂಟಿನ್ಯೂ ಆಗಿದ್ದಕ್ಕೋಸ್ಕರ ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಮಾರಾಟ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಸೆಕೆಂಡ್ ಸೇಲ್ ಡೀಡ್ ದ ಸೇಮ್ ವೆಂಡರ್ಸ್ ನಮ್ಗೆ ಯಾರು ಮಾರಾಟ ಮಾಡಿದ್ರು ಅವ್ರಿಗೂ ಅವರೇ ಮಾರಾಟ ಮಾಡ್ತಾರೆ. ನಮ್ಮ ಹೆಸರು ಬಿಟ್ಟೋಗಿತ್ತು ಸ್ವಾಮಿ ಅಲ್ಲಿ. ಆಗ ನಾವು ಗೊತ್ತಾಗ್ಬಿಟ್ಮೇಲೆ ನಾವು AC ಮುಂದೆ ಹೋದ್ವಿ, ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ. ದ AC set aside the mutation effected in favor of the respondent. DC confirms that against which the writ petition and appeal before this honorable court, my lord. And AC and DC stated in the orders that I am the first purchaser and mutation also affected, my lord. It is observed in the AC order, my lord. Mutation is affected in my name because the Tahsildar and assistant commissioner is the competent authorities to verify the documents. They are the custodians of the revenue documents. They only stated in the order mutation is affected in my name.
Kindly take the memo on page number 5 of the memo. Custodian of the artist is Krishna, who is categorically stated on comparison with page 645, what the appellant has produced.
Yes.
He has stated once I did that. The subject submitted to the appellant have produced a copy of the RTC of survey number 165 for the year 96-97 along with the written papers and data. If this applicant is institution has verified, cross-check the RTC produced by the appellant with the original RTC book available in. On comparison of RTC produced by the appellant and page number 1, so with the original code, it is clear that the RTC produced by the appellant, there are overwriting and tampering. The RTC produced by the appellant and page number appears to be not genuine one. Even his statement
Lord.
cannot be fine. They has total civil to establish that. But they should not have
My lord.
This, one second. The second RTC, the first RTC cannot be given. Second RTC, it starts from 94, 95, 95, 96. That's in column number 12. In column number 9, there was overwriting is there. So 95, 96 in column number 9, their name is not there. Now, members, I request members to turn the next page. 97, 98. So it is from 94 to 98 members. This is what is available in our office, and not this what the entity of it. So nowhere in the applicant's name is coming.
No, for 96, 97, where
It
is
is not there. It's not there. The particular year RTC of 96, 97 is not there. From 94 to 98 members. This is the second page. So still I get separate ಜೆರಾಕ್ಸ್ ಮಾಡಿ
ಅದು ವರ್ಕ್ ಇಯರ್ ಬರ್ದಿರೋದು ಹರಿದೋಗಿರೋದು ಕಾಣಿಸ್ತದೆ.
Yes, ಇಲ್ಲಿ ಹರಿದೋಗಿದೆ. This is not but while taking the xerox because it is so I myself still I get. It's required and original also I get. It is certified by okay, certified by reading of the next page not is certified. This is cannot live with the code like a interested party. Yes,
My lord.
Yes. Not like any interest in any of the parties. Yes, what is there? They have to settle all these titles, disputes to civil court. They can't do it. It's not a clean approach by
97, 98, Munikempaya, Sennamma.
ಅದು ಕಾಲಂ ನಂಬರ್ ಕಬ್ಜಾ ಕಾಲಂ ಓನರ್ಶಿಪ್ ಕಾಲಂ ನಂಬರ್ 9 ದಲ್ಲಿ ಬರಲೇ ಇಲ್ಲ. Gap maintaining that MR number is written. MR number 13, 14 and 15. Leonard Senior report respond as objective. MR ಇರಬಹುದು ಬಟ್ ಇದಕ್ಕೆ ಪಾರ್ಟಿಸಿ ಆಗಿಲ್ಲ ಅಂತ ಕಾಲಂ 1 ಬರುತ್ತೆ. Second RTC not in column 9. But it should not add the name in column number 9 in their RTC. That cannot be correct. You know, extraordinary jurisdiction. You cannot ask any person to enter the witness box and reduce. Time of issue, members will form the opinion, give a finding. To get that finding, they should not go to this extent. Extraordinary jurisdiction. Even though Leonard Senior once again identity order on that day who was pending. Nothing wrong in the order of the Leonard Senior. And nobody at least they would have said that no, it is not writing to the image of truth. But if we have been different, not in the affiliate forum, they should not have come and argue all this. Considering the Leonard title should take an then members will end. Otherwise, whatever is there, it should continue. What I feel on the records are there. People say that no, it is overwriting.
My lord, may I permit, my lord, with respect to one paragraph, my lord, I'll read in the orders of the deputy commissioner, my lord.
Which page, sir?
My lord, page number 101, my lord. It is page number 101 of the orders of the deputy commissioner, my lord. That is translated to the 101. And the original copy is that page number 95, my lord, in Kannada. Page number 95. ಅದು DC orders. DC order ಅಲ್ಲಿ ಅವರು ಹೇಳ್ತಾರೆ ಕಡತದಲ್ಲಿ may kindly read, my lord, page number 95.
Kindly read it, sir.
My lord, page number 95 in the last paragraph, ಕಡತದಲ್ಲಿನ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿದಾರರು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಬೆಂಗಳೂರು ಉತ್ತರ ಅಪರ ತಾಲೂಕು ಜಾಲ ಹೋಬಳಿ ಮಾರೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 165ರಲ್ಲಿ 6 ಎಕರೆ 39 ಗುಂಟೆ ಜಮೀನಿನ ಮೇಲಿನ ಹಕ್ಕನ್ನು ಕ್ರಯಪತ್ರಗಳ ಆಧಾರದ ಮೇಲೆ ಕೋರುತ್ತಿದ್ದು, ಪ್ರಶ್ನಿತ ಸ್ವತ್ತನ್ನು ಪ್ರತಿವಾದಿಗಳು ಅಧಿಕೃತ ಮಾಲೀಕರಿಂದ ಪಡೆದಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು, ಸದರಿ ಕ್ರಯಪತ್ರ ಪರಿಶೀಲಿಸಲಾಗಿ ಸದರಿ ಕ್ರಯಪತ್ರದಲ್ಲಿ ಮಾರೇನಹಳ್ಳಿ ದಾಖಲೆ ಚೊಕ್ಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 165ರಲ್ಲಿ 6 ಎಕರೆ 39 ಗುಂಟೆ ಜಮೀನಿನ ಖಾತೆದಾರರಾಗಿದ್ದು, ಶ್ರೀಮತಿ ಚೆನ್ನಮ್ಮ ಹಾಗೂ ಮುನಿಕೆಂಪಯ್ಯ ರವರಿಂದ ಚೊಕ್ಕನಹಳ್ಳಿ ದಾಖಲೆ ಗ್ರಾಮವಾಗಿದ್ದು, ಚೊಕ್ಕನಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಪ್ರತ್ಯೇಕ ಕಂದಾಯ ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಕ್ರಯಪತ್ರಗಳನ್ನು ಅನುಸರಿಸಿ ಕ್ರಮವಾಗಿ MR ನಂಬರ್ 13 96 97, MR ನಂಬರ್ 14 96 97ರಂತೆ ಈಗಾಗಲೇ ಪ್ರತಿವಾದಿಗಳ ಹೆಸರಿಗೆ ಖಾತೆ ಆಗಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಪ್ರತಿವಾದಿಗಳು ಇಸ್ ದಿ ಅಪ್ಲೆಂಟ್ ಹಿಯರ್ ಇನ್ ಮೇಲೆ. ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿದಾರರು ಮಾರೇನಹಳ್ಳಿ ಸರ್ವೆ ನಂಬರ್ 165ರ 6 ಎಕರೆ 39 ಗುಂಟೆ ಜಮೀನನ್ನು ರಿಜಿಸ್ಟರ್ ನಂಬರ್ 23802/2004 and 5 ದಿನಾಂಕ 17/2/2005ರಂತೆ ಶ್ರೀಮತಿ ಚೆನ್ನಮ್ಮ ಅವರ ವಾರಸುದಾರರಿಂದ ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಪರಿಶೀಲನೆಯಿಂದ ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿದಾರರು ಹಾಗೂ 4ರಿಂದ 9ನೇ ಪ್ರತಿವಾದಿಗಳ ಮಾರೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 165ರ 6 ಎಕರೆ 39 ಗುಂಟೆ ಜಮೀನಿನ ಅಧಿಕೃತ ಮಾಲೀಕರಾದ ಶ್ರೀಮತಿ ಚೆನ್ನಮ್ಮ ದೊಡ್ಡ ಹುಳುವಪ್ಪ ಮತ್ತು ಮುನಿಕೆಂಪಯ್ಯ ಲೇಟ್ ದೊಡ್ಡ ಹುಳುವಪ್ಪರಿಂದ ಖರೀದಿಸಿದ್ದು, ಇದರಲ್ಲಿ ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿದಾರರು ಪ್ರಶ್ನಿತ ಸ್ವತ್ತನ್ನು 2005ರಲ್ಲಿ ಹಾಗೂ 4ರಿಂದ 9ನೇ ಪ್ರತಿವಾದಿಗಳು 1995ರಲ್ಲಿಯೇ ಖರೀದಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಕ್ರಯಪತ್ರಗಳ ಆಧಾರದ ಮೇಲೆ ಉಭಯತರರು ಸ್ವತ್ತಿನ ಹಕ್ಕನ್ನು ಕೋರುತ್ತಿದ್ದು, ಕ್ರಯಪತ್ರಗಳ ನೈಜತೆಯನ್ನು ಪರಿಶೀಲಿಸುವ ಅಥವಾ ಪ್ರಶ್ನಿಸುವ ಅಧಿಕಾರ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮಾತ್ರ ಇರುವುದರಿಂದ ಈ ಹಂತದಲ್ಲಿ ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿದಾರರ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸುವುದು ಸೂಕ್ತವಲ್ಲವೆಂದು ಹಾಗೂ ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿಯನ್ನು ಪ್ರಶ್ನಿತ ಸ್ವತ್ತಿನ ಹಕ್ಕನ್ನು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪಡೆಯಬಹುದೆಂದು ಅಭಿಪ್ರಾಯ ಬಂದು ಈ ಕೆಳಕಂಡ ಆದೇಶ ಮಾಡಿರುತ್ತದೆ. The revision petition filed by the respondent, my lord, contested respondent, that revision petition is dismissed and the deputy commissioner stated in the order that MR number 13 14ರಂತೆ ಈಗಾಗಲೇ ಪ್ರತಿವಾದಿಗಳ ಹೆಸರಿಗೆ, that is appellants herein, ಖಾತೆ ಆಗಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. That documents which I produced the page number 645, my lord, mutations and RTC. That is certified, which I produced, my lord, before this honorable court.
Why there are no RTC standing in your name subsequent to 97, 98?
My lord,
According to you, only 1 year's RTC is there. What about the subsequent
ಏನಾಯ್ತು
years?
ಅಂದ್ರೆ ಮುಟೇಶನ್ ಆಗಿ RTC ನಮ್ಮ ಹೆಸರಿಗೆ ಬಂದಾದ ಮೇಲೆ their appellants are residing in Chikkballapura, Shitlಘಟ್ಟ ತಾಲೂಕು, my lord. The property in the Jalahalli in the North Additional Taluk, and they are not visited the Taluk office after the sale deed when mutation is accepted. ಆಮೇಲೆ ಅವ್ರು ಯಾವಾಗ ಇದಕ್ಕೆ ಹೋಗ್ತಾರೆ ತಾಲೂಕ್ ಆಫೀಸ್ಗೆ, ಅವಾಗ ಗೊತ್ತಾಗ್ತದೆ ಅವ್ರಿಗೆ ನಮ್ಮ RTC ನಲ್ಲಿ ನಮ್ಮ ಹೆಸರು ಇಲ್ಲ ಅಂತ. ಇಮಿಡಿಯೇಟ್ಲಿ ಅವಾಗ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಮುಟೇಶನ್ ನ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೆಸರಿಗೆ ಆಗಿದ್ದನ್ನ AC ಮುಂದೆ ಅಪೀಲ್ ಆಗ್ತಾರೆ ಸ್ವಾಮಿ. AC ಮುಂದೆ ಅಪೀಲ್ ಆಗಿದ್ಮೇಲೆ AC in the first round of litigation set aside. In the first round of litigation, DC also set aside, confirm the order of AC. Then it is up to the writ appeal ಬಂದು ಮತ್ತೆ ರಿಮ್ಯಾಂಡ್ ಆಯ್ತು AC ಗೆ ಮತ್ತೆ AC ಅವ್ರ MR ನ ಮತ್ತೆ set aside ಮಾಡ್ತಾರೆ. Against which again DC confirm the order of AC.
In the first round, the matter has reached up to
Yes, my lord. In the first round of litigation, AC DC set aside the mutation of the respondent, and the contested respondent filed up to writ appeal, my lord. In the writ appeal court remanded to the AC, my lord.
No, where is that order? Where is that order of the division bench?
My lord.
We are remanding the matter to the AC. Where is that order?
My lord, page number 343, my lord. My lord, relevant page, my lord, page number 350, 351, my lord. 351, my lord. In the foregoing circumstances, the assistant commissioner is required to give findings with regard to such discrepancies, and not only in the name of the village, and they also hold the inquiry with regard to mutation entry affected but not followed, etc., and observed in the order that the deputy commissioner, which is expected herein above. Thus, it is proper that the matter be remanded to the assistant commissioner to consider in the said aspect afresh by giving opportunity to both parties and put forth their case as directed by the deputy commissioner in order dated 18/6/2007. Accordingly, the above appeal is entitled to allowed hence following order. The appeal is allowed setting aside the order of the dated 19/11/2007 passed in WP number 12567/2007. And the entire matter in RA number 296/516 on the file of the assistant commissioner, Bangalore North Taluk, is remanded to him with a direction to decide the matter afresh in accordance with law, my lord. Thereafter, my lord, the assistant commissioner, after providing opportunity, my lord, passed an order, page number 104, my lord. After remand of the appeal to the assistant commissioner, page number 104, my lord. The page number 104, my lord. In the relevant page 106, my lord. May I kindly permit, my lord? It is seen that this authority is earlier round of litigation disposed of the appeal on 24/7/2006 and allowed the appeal filed by the appellant herein. Against that, the respondent have preferred a revision petition before the special deputy commissioner, Bangalore District, Bangalore, in RP number 85/2006 and 7, and the special deputy commissioner, Bangalore District, Bangalore, wide order dated 18/6/2007, set aside the order passed by this honorable authority and remanded to the merits of this honorable authority for fresh inquiry. Against the said order, the appellant herein had preferred a writ petition before the Honorable High Court of Karnataka in WP number 12567/2007, and the Honorable High Court allowed the writ petition and set aside the order of the Special Deputy Commissioner, Bangalore District, Bangalore, as per the order dated 19/11/2007. As against said order, respondent herein have preferred a writ appeal in WA number 2320/2007, and in the said writ appeal, the division bench of the Honorable High Court of Karnataka, by its order dated 28/8/2012, set aside the order passed by the WP number 12567/2007, as well as the order passed by this honorable authority in RA number 296/2005 and 6, and remanded this honorable court with the direction to decide the matter afresh in accordance with law, by providing opportunity to both parties, further directed to give findings with regard to such discrepancy not only in the name of the villages, and also to hold an inquiry with regard to mutation entry affected but not allowed, etc., as observed in the order of the deputy commissioner. The contentions of the appellant is that the appellant are the purchasers to the subject property bearing survey number 165, measuring extent of 7 acres, including 1 gunta food crop, situated at Marenalli village, Jalo Hobli, Helanka Taluk, Bangalore North Additional, under these 3 registered sale deeds dated 10/4/1995. And on the basis of the said sale deed, Kata have been transferred under MR number 12/13/14 of the 1996-97. The revenue entries were also affected and transferred to the RTC. Thus, for the all practical purpose, the appellant are still the holders of the Kata in respect of the land, as the mutations are still subsisting and in operation, which when such being the position, respond number 6 and 7, who are already sold the land in question to the appellants, just because the revenue entries continued in their appellant's vendor name, that is my appellant's vendor name, my lord, name, they seems to have again sold the same in favor of contesting respondent number 125, who got the impugned mutation accepted in their names in collusion with the respondent number 8 and 9. Respondent number 8 and 9 accepted the impugned mutation in favor of the contesting respondents, without even not complying with the requirement of natural justice and giving an opportunity, though the names of the appellants are appearing in the revenue records, MR and RTC, which is patently illegal and is in violation of Rule 65 of the Karnataka Land Revenue Rules. Hence, filed an appeal along with an application for condonation of delay. Notice issued to the parties. Respondent number 1 to 5 appeared through their counsel and filed the objections contending that under a registered sale deed dated 17/2/2005, they have purchased the total extent of 6 acre 39 guntas of Marenalli village, Jalo Hobbli, Bangalore North Taluk. And based on the above sale deed, the revenue entries have transferred their name wide MR number 52, 2004 and 5. Their contention, my lord. Thereafter, my lord, the Honorable Assistant Commissioner, last paragraph, my lord, heard the arguments and perused the records. Delay in filing the appeal is hereby condoned. By going through the contentions urged by the parties, in real controversy between the parties are that both of them are claiming have purchased the land bearing survey number 165 from respondent number 6 and 7, who are admittedly owners of the property. The extent of the land is same and the survey number also same. In the sale deed executed by the respondent number 6 and 7, along with other family members in favor of the respondent number 1 to 5, the description of the property in the land bearing survey number 165 measuring 6 acre 39 guntas of Marenalli village, Jala Hobbli, Bangalore North Taluk. From the material on record, it is nobody case that the respondent number 6 and 7 owned 6 acre 35 guntas in survey number 165 in both village, that is Marenalli and Chakkanalli. On the contrary, the boundaries given in the both sale deeds are identical. Further, the averment in the sale deed dated 17/2/2005 shows that the respondent number 6 and 7 acquired the property under a registered sale deed dated 4/6/1961 by document number 1567/1961-62. And the said document is produced by the respondents. By going through the same, it is seen that the property owned by them and sold in favor of the appellants and respondents are situated in Chakkanalli village, Marenalli Dakale, Devanalli Taluk. The same recital are shown in the sale deeds in favor of the appellant here. Therefore, it is clear established that the land sold in favor of the appellant under the registered sale deed dated 10/4/1995 and in favor of the respondent number 1 to 5 under registered sale deed dated 17/2/2005 are one and the same. From this, it is clear that the property which is subject matter of the land in both sale deeds one and the same, and vendors are one and the same, and only purchasers are different. Further, it shows that there are no two separate village, Marenalli and Chakkanalli. As the appellant have acquired the right over the subject land in the year 1995, accordingly, the mutation entries have been in their name. The Tahsildar cannot make entries in the name of respondent number 1 to 5 on the basis of the subsequent sale deed, which came to existence in the year 2005, wherein the vendors of the respondent number 1 to 5 have no title over the property. Therefore, I am the opinion that the impugned MR, which is made in the name of the respondent number 1 to 5, is not sustainable, and same is called for interference. Hence, I proceed to following order, my lord. The appeal is hereby allowed. Impugned MR number 52, 2004 and 5, dated 18/6/2005, which is in the name of the respondent number 1 to 5, is hereby set aside. And this order is confirmed by the Deputy Commissioner, my lord.
Mr. Counsel, how the Assistant Commissioner can hold that respondents 1 to 5 have no title over the property? Can title of any?
No, my lord.
Assistant Commissioner. Title to the property could be decided by the Assistant Commissioner.
No, my lord. That is the reason, my lord. That is the reason Deputy Commissioner held that the Deputy Commissioner held that this authority has no jurisdiction to go before the civil court, my lord. After confirmation of the order, the Deputy Commissioner passed an order, my lord, at page number 92, my lord.
92.
92 DC order, my lord.
Yes. Yes. Yes, sir.
My lord, 92 in the page number 11, page number 96, my lord. In the last portion, he stated, my lord, the last portion, ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಪರಿಶೀಲನೆಯಿಂದ, page number 96, my lord. Because
Yes, sir.
the revenue authority cannot decide the title, my lord. I'll agree for that, my lord. That is the reason Deputy Commissioner stated in the order that ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಪರಿಶೀಲನೆಯಿಂದ ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿದಾರರು ಹಾಗೂ 4 ರಿಂದ 9ನೇ ಪ್ರತಿವಾದಗಳು ಮಾರೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 165ರಲ್ಲಿ 6 ಎಕರೆ 39 ಗುಂಟೆ ಜಮೀನನ್ನು ಜಮೀನಿನ ಅಧಿಕೃತ ಮಾಲೀಕರಾದ ಶ್ರೀಮತಿ ಚೆನ್ನಮ್ಮ ಲೇಟ್ ದೊಡ್ಡ ಉಳುವಪ್ಪ ಮತ್ತು ಮುನಿಕೆಂಪಯ್ಯ ಬಿನ್ ಲೇಟ್ ದೊಡ್ಡ ಉಳುವಪ್ಪನನ್ನು ಖರೀದಿಸಿದ್ದು, ಇದರಲ್ಲಿ ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿದಾರರು ಪ್ರಶ್ನಿತ ಸ್ವತ್ತನ್ನು 2005ರಲ್ಲಿ ಹಾಗೂ 4 ರಿಂದ 9ನೇ ಪ್ರತಿವಾದಿಗಳು 1995ರಲ್ಲಿಯೇ ಖರೀದಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಕ್ರಯಪತ್ರಗಳ ಆಧಾರದ ಮೇಲೆ ಉಭಯತ್ರರು ಸ್ವತ್ತಿನ ಹಕ್ಕನ್ನು ಕೋರುತ್ತಿದ್ದು, ಕ್ರಯಪತ್ರಗಳ ನೈಜತೆಯನ್ನು ಪರಿಶೀಲಿಸುವ ಅಥವಾ ಪ್ರಶ್ನಿಸುವ ಅಧಿಕಾರ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮಾತ್ರ ಇರುವುದರಿಂದ ಈ ಹಂತದಲ್ಲಿ ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿದಾರರ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸಲು ಸೂಕ್ತವಲ್ಲವೆಂದು ಹಾಗೂ ಪುನರೀಕ್ಷಣಾ ಅರ್ಜಿದಾರರು ಪ್ರಶ್ನಿತ ಸ್ವತ್ತಿನ ಹಕ್ಕನ್ನು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪಡೆಯಬಹುದೆಂದು ಅಭಿಪ್ರಾಯಕ್ಕೆ ಬಂದು ಈ ಕೆಳಕಂಡ ಆದೇಶ ಮಾಡಿರುತ್ತದೆ. The Deputy Commissioner held that the civil court have competent to decide the title of the property on the basis of the sale deed, my lord. The civil suit already pending, invoice number 401/2006, my lord. That civil suit for injunction, my lord. In that civil suit, admittedly, I filed an application for declaration. This honorable court held that I am the first purchaser. Therefore, there is no need to seek the amendment for declaratory relief, my lord. Therefore, that suit came to be finality by decreeing the suit filed by the appellant, my lord. Against that suit, the contesting respondent filed the first appeal, my lord, RA number 17, my lord. In the first appeal, my lord, that is pending before the honorable trial court, and also filed an application for stay of the impugned order. The stay application already rejected, my lord, which the document already produced before this court, my lord. Now the RA is pending before the honorable trial court. Now the Deputy Commissioner holds that the civil court has the competence to decide the rights, and I am the first purchaser. The contesting respondents are the second purchaser. Now the mutation entries MR number 13, 14 are mutated in my name 95, 96, my lord. That I produced the certified copy before this honorable court, my lord, is the page number 645, my lord. And the survey in the RTC with respect to 96, 97, my lord, I produced the copy, my lord, and certified copy also I have, my lord. I will produce that is also, my lord, because what the file my friend in the memo, my lord, 96, 97 RTC is not there, my lord. And my friend stated that adu illa ali ಶೀತಲವಾಗಿದೆ ಅಂತ ಹೇಳಿ. Let the original records may be called, my lord. Let verify the records, my lord, because I taken certified copies from the taluk office, my lord, and they certified that they issued the copy. The same is produced before this court, my lord. Therefore, the 96, 97 RTC and mutation reflected first instance on my name, my lord. Subsequently, when discontinued my name in the RTC, when returned back to my vendor's name, my vendors taken an advantage of that entries in the revenue record.
Why for the subsequent years your vendor name is entered in the RTC?
My lord,
That is the main question.
my lord, ಇವರು ರೆವಿನ್ಯೂ ನಾವು ಯಾವಾಗ ಮುಟೇಶನ್ ಆಗ್ಬಿಟ್ಟು RTC ಆದ್ಮೇಲೆ ನಾವು ಹೋಗಿಲ್ಲ ತಾಲೂಕ್ ಆಫೀಸ್ಗೆ ಸ್ವಾಮಿ. ಆಗಾಗ ಏನಾಯ್ತು, ನಮ್ಮ ಹೆಸರು ಬರ್ಲಿಲ್ಲ ಅಲ್ಲಿ. ನಾವು ಹೋಗಿ ಚೆಕ್ ಮಾಡಿದಾಗ ತಾಲೂಕ್ ಆಫೀಸ್ಗೆ ಅವಾಗ ನಮ್ಗೆ ಗೊತ್ತಾಯ್ತು ಆಲ್ರೆಡಿ ಇದು ಬೇರೆಯವರ ಹೆಸರಲ್ಲಿ ಇದೆ ಅಂತ.
The sale deed, after the mutation entries were effected in your name, after the RTC standing for 1 year your name, subsequently if it is not shown in the RTC, person keeping
my lord, that is when I came to the knowledge about the subsequent entries, immediately I challenged the same before the State Commissioner by filing the appeal under section 136(2) of the Act, my lord.
No, your lordship had heard the entire matter. Specifically in the order note, it was noted that the records have to be produced only to examine. One is 96-97's RTC note, and whether at all at any point in time their names are entered. To show whether it is being displayed.
Clear also, we have heard both the learned senior counsel for the parties.
Yes.
Only to hear the learned AGA regarding this mutation in
Yes,
the
now the AGA has
RTC
filed not the entire original record.
RTC for only 1 year was produced. What happened to the other years RTC that we
No, even
wanted
that
to
1 year is not there.
maybe
No, that is what the government record says.
That is what that is. Is it requested
My
the
lord,
learned
that is certified copy.
In fact, the memo says not that this is a fake.
Permit to produce the certified copy of the 1 year RTC, my lord.
So they have not
I
even
will
come
produce
before
before
the
this
court.
court.
Great respect. SLR says that it's a fake one. Ultimately, civil court has to say neither this court nor the revenue authorities to decide anything on.
We cannot, yes, we cannot adjudicate this.
Second RTC, third RTC, from subsequent errors as like pointed out, from 97 to again up to 2005 was again the vendor's name. At least 1 year, so that errors would have delivered that was that is genuine. Subsequent 4 RTCs, nowhere their name is.
My lord, in the RTC produced by my friend, my lord, in the second RTC, my lord, it is reflected, rounded off the Munikampaya and entered in the name of the Ramakrishnappa, my lord. In the second RTC, which produced by my friend advocate, my lord.
What happened? That is the reason we are again putting the same question to you, and your answer is that you were not so serious to follow the revenue records.
My lord, why? Because my lord, reason is that, my lord, the appellant residing in Chikballapura district, my lord, and the property situated in Jalalli, my lord, because they are the senior citizen, my lord, they cannot visited the office of the Taluk office. Therefore, the reason when he visited the Taluk office and he came to know, immediately challenged the mutation which wrongly entered before the AC, my lord. That AC, after holding the inquiry by issuing notice and hearing the parties, my lord, set aside the mutation, my lord, which affected in the name of the respondent, my lord. Against which this proceedings.
You know very well how the parties purchase the properties, looking at the encumbrance, looking at the RTC extracts.
My lord, after they came to the knowledge, my lord, after they came to the knowledge about the subsequent sale deed and the mutation and encumbrance, my lord.
Yes, if the property stands in the original vendor's name, property is purchased by any common man, sir.
My lord, that is.
Not challenged at the relevant time. Yes.
My lord, when after the mutation, my lord, when the appellant visited the office, my lord, then only came to know, my lord. Immediately they take an action, my lord.
To be decided in a civil court, sir. We cannot adjudicate.
RS 17 of 21 is filed against individual lots. If any person files a civil suit outcome of it, again, my lord is not deciding any of the time. If you put any declaration,
my lord, now this honorable court heard, my lord, as per the documents, my lord, documents available on record, my lord. Admittedly, I am the first purchaser, my lord, and also mutations which affected in my name.
Today we have provided an opportunity for you also to make your submissions subsequent to the learned AGS made his submission. We have heard your both of
Lord, I may permit produce the copy of the certified, my lord, again because I taken.
It doesn't make any difference for 1 year. Our question is what we wanted to get clarification from the AGA was only for 1 year why that RTC is there. The other subsequent years.
My lord, kindly my request, my humble submission, my lord. The original records may be called for, my lord. Why they are again re-entered, my lord? Because once my name is entered, my lord, the revenue authority have to continue my name, my lord. They cannot change in spite of my name to others' name, my lord, because they are the authority on the base of sale deed. They have to continue my name, but there the revenue authority discontinued my name, my lord. Therefore, the names are entered in my vendor's name, and by taking advantage, my lord, they executed subsequent sale deed, my lord. Because the revenue authority on the base of the sale deed, they have to continue to my name, my lord.
Yes. The appeals stand dismissed.
Well,
Very good.
Yes. Again for impleading also stands dismissed. All the pending is, yes. Yes, I also stands dismissed.
Please. Lord,
Yes.
my lord, I'm appearing to the appellant in this case, my lord.
Yes.
My lord, I seek for a short accommodation, my lord. We'll receive the wakalat by the end of the day, my lord. I'll file the wakalat.
If after makes of the request of the learned court is appearing for the appellant.
I appear for the petitioner, my lord.
My lordship, I am appearing for respondent 1, my lord. My lord, I humbly praise that senior have some family inconvenience, my lord. Now, for next week, Monday may be date given, my lord. Any week, my lord. In next week, my lord.
My lord, interim order may kindly be extended, my lord.
Interim order granted. You are appearing for the respondent number, which respondent, madam?
1, my lord. Respondent number 1.
Interim order granted, earlier stands extended to the next year. Yes.
Much surprised, my lord.
Now, where is Mr. Abhinay? Abhinay Vaiti? Let him come. That is Cora.
I represent the appellant, 27, if I am right.
Sir.
Lord, this is a claim with respect to recovery of differential of freight charged by the railways. In fact, I had booked the rakes to carry my iron.
Vaiti is there for
Pardon.
Padmanabha Valla.
Yes, I am for respondent, my lord.
I am sorry, man. I am sorry.
Number 2,
I am
my
in
lord.
27.
Yes. Respondent, you are ready, sir?
Yes, I seek a short adjournment, my lords. I request the trial court records have come, my lords.
Whether trial court records are available?
Yes. 27.
27, my lords.
Yes,
I am for respondent number 2, Konkan Railway Corporation, my lords.
Yes. Now it is for admission. Whether records are required for admission?
May not be, my lord. May not be.
Yes.
The reason being that, Lord, my booking was done in a longer route. I preferred a longer route because the congestion, there would be traffic congestion there, as per the advice of the second respondent of Konkan Railways. And I paid freight for a longer route. And about a particular part of my cargo was moved in a longer route, and about 18 rakes were moved in a shorter route, Mangalore, Hassan Mangalore route. And there was an agreement between me and the second respondent for refund of some money as a concession for having booked the material in a longer route. That is a new route. They wanted to promote that route to the customers. So I, being one of their customer, I opted for the longer route and paid more money. 15.52% was offered as a rebate on that longer route. There is no dispute about these aspects. And all the materials I booked was on the longer route. About 18 rakes were moved by the railways in a shorter route, that is from Mangalore Hassan route. They did not move it in the longer route for obvious reasons. We do not know. They don't say why, what for they moved it in a shorter route. They don't say anything. But when I make a claim for refund, they give refund for those which have been moved in a longer route. For 18 rakes, they say we are not liable. Though there is an agreement that I must get back 15.25% as per the agreement which is produced as Annexure A2. There is no dispute about these aspects also.
Yes, admit.
And
Call for records.
Please, my lord.
Great, please, your lordships. Lord, I appear along with Mr. Prasad, my lord, in this MFA, my lord, which arises, my lord, under the Foreign Exchange Regulation Act. Lord, I've also given a small dates, event synopsis, and also my submissions along with the authorities. Your lordship has that, my lord?
Yes.
Yes. Lord, the appeal, my lord, arises under Section 54 of the Foreign Exchange Regulation Act against the order of the second respondent appellate tribunal, confirming penalty. Lord.
We will hear the appellant counsel. Yes.
Yes.
Not
Lord,
the matter. Yes.
The penalty of rupees 10 lakhs, my lord, has been imposed for contravention of Section 91B, and the penalty of rupees 20 lakhs for contravention of 91D of the FERA 1973. There is also, my lord, an order of confiscation of Indian currencies to the tune of 4.38 lakhs and balances in the bank account of Vijay Agencies, Taj Enterprises, Azad Traders, International Spices, SN Enterprises, and FDs in Vijaya Bank in name of Vijay Agencies, totaling to about 20,83,444. But the charge against the appellant is that he had received an amount of rupees 12 crores 9,69,179 by order or on behalf of Abdul Salam of Abu Dhabi, a person resident in outside India, without the general or special permission of the Reserve Bank of India, and distributed an amount of rupees 11 crore 90 lakh 47,249 to local persons, thereby contravening 91D. Lord, your lordship will straight away go to the synopsis which I have filed and take the dates and events chart, my lord. Your lordship will kindly go to. Page 1 to 6 is the synopsis and dates and events chart. My lord, I have not set out, my lord, the dates and events at page 2. Your lordship will kindly go through. I will just read, my lord, from the table.
There is a synopsis here.
Lord, there is one separate book which has been given, my lord, dated 28/3/2016. Your lordship has that?
Oh, this is this book.
Yes, booklet.
Yes.
Running to about 155 pages. More than, yes, 155 pages. Your lordship has that, my lord?
Yes, sir.
Yes, your lordship will kindly go to page 2. Kindly see the dates and events in this case. Lord, on 26/9/1991, my lord, officers of the Enforcement Directorate caused a search of the premises of Vijay Agencies, Bangalore. Indian currencies of rupees 4.38 lakhs are seized along with certain documents. Then on 26/9/1991, a first statement in terms of Section 40 is recorded from the appellant by the Enforcement Directorates. Now, he states that he met Abdul Salam of Kannangad, Kerala, who was introduced to him by one Abdullah of Nileshwar in 1990. Salam told him that he was having a supermarket at Abu Dhabi. Salam offers to arrange for payments to him by cash, checks, etc. The said monies are to be handed over to persons sent by Abdullah of Nileshwar. Appellant is promised commission of rupees 100 per lakh distributed. Then telephone number given by Salam at Abu Dhabi and that of the appellant at number 34487. Salam also told him that Hamid of Mumbai would call him and inform him the mode and method of disbursement. Telephone number 2551 of Kareem of Kannangad is given to the appellant through which he could contact Abdullah. He is explained sheet number 3. The appellant states that it is amount relating to receipts of amount from Abdul Salam and payment to Abdullah during the 3rd week of September 1991. He states that an amount of 20 lakhs were laundered in the month of for 9 months, amounting to 1.80 crores. Then on the very next day, my lord, a statement is recorded from one Muralidharan, manager of the Federal Bank. He states that Mrs. SN Traders were maintaining a current account with branch and deposits were made into the account, and Lokesh, employee of the appellant, used to come for encashment of checks. He also states that he met Prakash, the appellant, a few times in the bank. Then a second statement your lordship will kindly see is recorded on 27/9/1991. He says SN Traders, his proprietor is one Suresh Kumar. He used to sign the checks as Suresh Kumar. 1990 onwards, he received checks, drafts, etc. as per the instructions of Abdul Salam, and also cash which was deposited into the accounts. The amounts were withdrawn and paid. Current account of Taj Enterprises was opened by Abdullah of Nileshwar. Deposits from Hamid of Mumbai at the instruction of Abdul Salam used to be made in the above account. The account was operated by Rajesh Shetty, power of attorney of Abdullah. Lokesh used to encash the check. Azad Traders account was in the name of Mitesh, which is the appellant himself. Then, my lord, on 27/9/1991, a statement is recorded from Dhanapalan, branch manager of Tamil Nadu Mercantile Bank. He talks about the operation of bank account in the name of Vijay Agencies, Taj Enterprises, and International Spices, and deposits of the amount by check, withdrawal of the same. Then on 27/9/91, the residence of the appellant is searched with nil results. Then on 27/9/91, statement of Lokesh, employee of the appellant, where he talks about deposit and withdrawal of checks, etc. That is it. Then on 28/9/91, statement is recorded from the brother of the appellant called Pradeep Kumar.
First of all, who is this appellant, sir? Who is
the appellant, yes.
This Vijay Agencies?
No, he is the proprietor of Vijay Agencies. He is connected with, he is connected. Yes. He is the proprietor and he is also the authorized signatory of the other firms also. He is in the business of trading in spices. The case booked by the Enforcement Directorate is that he had received certain amounts at the instance of a person resident outside India and distributed what is known as Hawala. That is the charge. 91B and 91D are the charges, for which, my lord, material was gathered, investigation was conducted, a show cause notice came to be issued on the basis, basically on the basis of statement recorded from him and statement of others, and some chits, etc., which were seized. And ultimately, what happened was an order in adjudication came to be passed by the Special Director of Enforcement, levying the penalties and confiscating the amounts. I went to the tribunal. I contested the matter before the tribunal. Tribunal has now affirmed the order of the adjudicating authority and confirmed the confiscation and penalties, against which I am in appeal before your lordship. Lord, in fact, my lord, the last time the appeal was taken up in sometime in 2016, the entire set of records were directed to be produced by the respondent because I didn't have any records. I only find the appellate order, the original order, and I have now filed a synopsis, my lord, which encapsulates my full submissions in the appeal. The entire case of the department is built on statement, which is retracted, and I will be able to show to your lordship that the statement which was recorded on 26/9/26/7 is completely, my lord, not a correct statement. It has been retracted on 110, and that retraction is on record. Lord, if there is a retracted confession of an accused, of a person charged, then the department has to produce some evidence, my lord, of corroborative nature, by which are independent to sustain the charge. There is no such evidence.
You are for the appellant. Yes?
Lord, I appear along with Mr. Prasad. Lord, Mr. Prasad is my colleague there. I am Satish Sundar, advocate from Chennai. Lord, I am the second counsel on record.
Sir, Prasanna Kumar is appearing for the department. Huh?
Yes, Mr. Prasanna Kumar appears for the department. Earlier, Mr. Mahesh was there. Yes, Mahesh. I think Mr. Prasanna Kumar would have come into the picture.
We have to hear him also. Today is.
Yes, I'm not, if your lordship will kindly fix up a date, my lord, after all, it's a appeal of the year 2014. And my lord, the incident, my lord, took place sometime in 1996-97. And I am yet to see the light of the day, my lord, of the appeal. Your lordship may fix a date, and I'm ready with the matter. My lord, I've also given my synopsis to my friend so that he can be ready with the whatever case law he wants to file. My case is, my lord, the retracted statement of the appellant cannot be a basis on which a penalty can be levied nor confiscation made. There has to be independent evidence of corroborative nature. That is lacking. I'll be able to demonstrate to your lordship that the entire exercise done by the appellate authority and the lower authority is on the basis of the statement which has been recorded and retracted. Lord, I have also some citations to place before you, Lord.
Said your own convenient date. Don't seek for adjournment on the date again. Huh? Monday or Tuesday may not be Friday. Any Thursday, Friday. 24th, shall we have it? Yes.
24th, my lord.
Yes.
24th is fine with me. Absolutely no difficulty. I'll be joined on virtual mode.
Yes, sir. We at this 2014 matter, how can stay now, sir? Sorry. Huh? Huh? It's not before us. No, in which we are seeking stay. Yes, next matter.
Your lordship is giving any particular date, my lord?
February, sir.
Appeal number 30, my lords, I appear for the appellant, my lords, in MFA 8478, my lords, of 14. My lords, in this matter, previously, my lords, we had sought time to report conclusion of OTS. An OTS, my lords, had been entered into, my lords. Out of the 4 installments, my lords, that had to be paid, the 3rd installment, my lords, was paid yesterday. My lords, there was some delay in making the payments due to the 3rd wave of the pandemic, my lords, which just happened recently. If your lordships would please grant us 3 weeks time, Lord, we'll report no dues and the matter can be closed.
Arabati? Representation on behalf of the respondent.
In the companion appeal, I am appearing for the appellant, my lord. 113. Yes, my lord. 113 of 15.
Then what you will say, madam, about their submissions now made?
Yes, my lord. Settlement is going on.
You remove for 3 weeks. Because settlement. Direct counsel for the respondent. Appellant in MFA 113 of 2015 does not dispute the same. The matter after 3 weeks.
Great.
Bless.
Paying for the appellant, my lord. Challenging the order passed by the appellate tribunal, my lord. The proceedings are arising out of Prevention of Money Laundering Act, my lord. Under the Money Laundering Act, my lord, appellate tribunal has rejected the department's claim, my lord, and it has come to a conclusion that since with respect of schedule offense.
Kindly wait for some time, sir. Learned counsel for the respondent.
Sorry, madam.
Yes.
There I have a question questions with the several petitioners because same is written for the Honorable Apex Court. Including the enforcement of the hearing going on with the second very Honorable Apex Court. Really after 2 weeks, it will be decided. What if questions are posed with the Apex Court?
Then we'll have it in the second week of March.
Yes,
Learned counsel for the respondent submits that the issue involved hearing is seized off by the Honorable Apex Court. The matter is now heard.
Going on, that is urgent to push.
May I make one submission, my lord? The finding of the tribunal is that it is a dependent on the proof of the schedule offense. But the division bench of this honorable court, my lord, has come to a conclusion that the offense under the PML Act is a standalone offense. It is not dependent on the schedule offense.
All those questions are now before the Honorable Apex Court, and the matter is now under the it is here. They are hearing the matter. This the matter, or in the second week of March. It's the matter. March. At the request of the learned counsel, appearing for the appellant. Yes. ಈಗ finally the ವಕಾಲತ್ ಜಗದೀಶ್ ಮುಂದರ್ಗಿ No, the other side is not present here. It can come. Phone ಮಾಡಿ ಕೇಳಿ court officer. Yes, what is the matter, sir? This appeal is by the CH3. Yes.
9. That is communication to the surety, communication to the guarantor. After selling up the primary assets, if we have returned to the guarantor of the guarantor of the unit, requesting them that the primary assets have been sold at 3,30,000 rupees. If you have any better offer,
Court of Karnataka.
Jagdish Kundarage.
So the date of this notice, daily further action will be initiated for the sale of assets. Here also, in the first paragraph of the page number 10, buyer offer received is rupees 3,30,000 rupees. Since you have not brought any offer, this is to inform you that the sale of the asset as the rule is proposed to be concluded, that is sold subject to the following conditions. So this clearly shows that we are transferring the seized asset. The page number, document number 4, table notification.
What is the issue involved here, sir? No, last time, no, this is a bench. We don't know whether the same bench. You have to apprise us now, sir. What is the matter all about? Not a synopsis, just to encapsulate what is the matter involved on.
For respondent in this matter, my lord, in serial number 33, they have produced some documents in the morning, my lord. They have not served copy, and as we want to go through the documents.
One time or you are the Mr. Counsel for the respondent. Shall we hear the appellant counsel? You want
please.
you are speaking time or shall we hear the appellant counsel?
My lord, we want to go through the documents. Let him serve the copies, because the court suggested him to produce the documents.
The record says some documents, those are the original documents. You can, physical appearance is permitted. Why can't documents which are now filed before the court?
In the next week, my lord, please, my lord. Senior is not available today. Next week, we will.
List the matter. Yes, list the matter by next week. At the request of the learned counsel appearing for the respondent in 2016. You have also filed an appeal.
A cross objection I have filed one.
What is your matter? You are ready with your matter?
Next week, my lord, please.
Where is Mr. Abhinay? Yes. Yes. So we have passed over both these matters can be taken. No, we don't. Yes. Ah. Even the limitation aspect we have to consider. What is the order? Original order? 22nd January 2016 is the review order. Yes. First of what do you have to? Yes. Right. Yes.
They are not specifically excluded by special law or local law. 4 to 24 should be expressly excluded. But this express exclusion.
No, you kindly repeat your submission.
Section 29(2). There should be express exclusion of section 4 to 20.
Express exclusion where?
The local, the other special. Special or local law should be described in the schedule. What is described in the schedule? Also, section 3, but in here it is described in the schedule. And for the purpose of determining any period of implementation, described for any suit or application by any special law or special or local law, the progress contained in section 4 only so far and to the extent to which they are not expressively excluded by the special or local law. So the special or local law should make express clause that they shall exclude the certain sections of limitation. If such an expression is added, then those provisions of limitation do not apply. Supreme Court would not such section 29(2). Yes, it should not be it should not be compulsory expressed. This section that implies exclusion. Then
I think under the Motor Vehicles Act, there may be some provision relating to this the same issue, that there was no the limitation was prescribed under the Motor Vehicles Act. Whether section 5 of the Limitation Act is applicable or not has been the subject matter of some appeal or some petition which I have come across. Not on the railways, but under the Motor Vehicles Act, maybe under the Motor Vehicles Act. But there is some when there is an appeal provision provided under special statute, whether section 5 of the Limitation Act could be made applicable or not was the issue. That is, yes, that is.
Not thereafter this express exclusion of the Limitation Act.
Yes, that is true.
But in this section, there is no such part. Simply provides 30 days is to be as a period of excluding the section of the process. This one we have to see whether the reject
Now this appeal is filed beyond 90 days. Beyond 90 days.
I find it on 1st of June.
But so far there are no such appeals filed. No, objected ಅಲ್ಲ, whether you have filed it beyond the 90 days and section 5 was made applicable. Yes, what do you say, sir, on this preliminary point? No.
Conflicting judgments of IPS.
Yes.
Yes. Certain high courts have taken the view that the Railway Trades Tribunal Act is a complete code in itself, and therefore the provisions of section 5 do not be. There are certain other languages. Section 5 of the Limitation Act also be applicable to appeals filed in the section.
Yes, let us see.
As far as our report is concerned, that's no.
Let us see those judgments. First, we'll close this point. Yes. On this limitation point. So many judgments have been referred. Yes. Would apply to the Friday. So you can come to the relevant paragraph instead of reading the entire thing. It runs to how many paragraphs? 70 paragraphs. Yes, if it is required, we will go to this in its entirety. Come to the relevant paragraph. Page.
Paragraph 66.
Taxation. Appeal cannot be filed under section. Section 5 is not applicable, I'm saying. Yes, sir.
And the position of law later when you go to Supreme Court, it's the principles, of course, that was not under the previous case, like the principles it is applied. Supreme Court judgment, which is not on the case study, that I request the Lordships to look at the judgment. Page 13. The judgment of the property court. This is a much shorter judgment, but the question is posed in page 14, paragraph 1. The common question that arises for application in these batch of cases is whether the provisions of Section 5 of the Litigation Act is applicable to condone the delay in filing an appeal under Section 3 of the Railway Claims Tribunal Act. As agreed to by the Learned Counsel's common and identical question having reason for the decision on the cases are presented. Then I got, in terms of the finding of the court, page 16. The Railway Claims Tribunal Act, enacted by the Parliament for the purpose of dealing with claims for damage suffered by the claimant on account of accidents involving a passenger train, as well as for loss of goods in the railways not satisfied. And the litigation in the courts of law and before claims commission to and then the survey of the different provisions of the Act shows that the legislature has provided a power to control the delay in filing the application for the Act. It's sufficient as shown by the applicant for not filing Here the Railway Claims Tribunal has the power to control delay, which is expressly provided for in Section 17 of the Act. But there is no similar provision to extend or condone delay in Section 23 of the same Act, which thereby leads to the impression or the indication that the legislature intended that only the Railway Claims Tribunal could
SC 17.
These are applications that are filed under Section 13. Section 15 bars jurisdiction of Indian courts for the Railway Claims Tribunal, which is specialized Claims Tribunal is not application for any claim. And there's of course one of the applications made in 3 years. Then whereas in respect of other causes of action, it is again 1 year or 2 years. Then whereas what is relevant is 17(2), standing anything contained in subsection 1. Conferred on the Railway Claims Tribunal. But NDC number, Section 23, which is the appeals provision. A was provided in subsection 2 and notwithstanding anything contained in the Code of Civil Procedure. The order not being interlocutory. No use in life of another. Under the and the relevant argument is that if your provisions of the Application Act 1988, and that's the view that is because the Military Claims Tribunal Act is a complete code, and that is the reason why it's a complete code is also when for expressing the act itself, section 7, section 8. Act notwithstanding anything inconsistent. This has been considered. Clause 18 may also be looked at. I'm so sorry, but section 18 may also be looked at. Procedure and powers of claims tribunal. These tribunals shall not come by the procedure laid down by the CPC, guided by principles of natural justice, subject to granted orders to this act, and the very rules. Claims tribunal shall decide every application as expeditiously as possible, and ordinarily every application should be settled by scheme of the act which has persuaded the government take a view that in respect of appeals valid for section 23 runs applications for combination of the act. Based on this scheme, the property right this analysis kindly see notes paragraph 13 of the judgment and page 17 of the judgment. The legislature has provided the power but no such power is provided in respect of preferring an appeal and the legislative mandate as contained in section 2 is to be establishment tribunal is for speedy cases. Is to be seen whether there is any power provided by the appeal and the provision of the relevant laws. In terms of the provision contained under section 23, the act not rules to be relevant as respected. But if you look at paragraph 20, the given under article period of section where the period of period of limitation under the Limitation Act as prescribed under section 23 of the Railway Claims Tribunal Act are the same and not different. About the Railway Claims Tribunal objects, exercising any and for that purpose when you take any application. Is under the Civil Excise Act. Expected. Paragraph 8, which is extracted in this excise jurisdiction to control the daily demand people. Further, the vice of subsection 1 section the regulatory authority therefore, there is complete exclusion of similar view has been taken by the disturbance and so provisions of the Kerala Land Act. Like then another paragraph 87. In the instant case, prescribed under the same, that is 90 days. As indicated herein above, enacted the act, the specific object of speedy adjudication of the same cases in filing the application has been recognized in case of the legislature being conscious of the relevant facts and considering the object of the act did not make any provision for condemnation of the legal violence.
So what happened? This is one a single judge order, whether it has reached its finality.
Yes, in fact, this has also been applied by subsequent this is High Court takes this view.
No further challenge has been made. This is one a single judge's order.
Yes. This does not seem to have been challenged. In fact, this is a 2000 judgment which applies the same judgment. Once I produce a copy of it. But unfortunately, I can't copy this.
Even this has attained finality. That this has attained finality.
Whereas we have checked whether it has not been challenged with the petition. We have checked online. There seems to be
No, before the division bench at least. No.
Since the English is the common respondent of these words, you probably be able to say
Madhya Pradesh. Yes, sir.
you can verify if there are any other conflicting that is I just complete reading that judgment because the analysis.
It's one that Zaisuruddin Talukdar.
Paragraph 28, 29, and 30. And the picture of the statute. There is a no appeal lies. Accordingly, the necessary period of limitation prescribed or fixed for filing the appeal would also be required and followed as per the mandate of the circuit itself. As in filing the appeal by necessary application. Such purpose, the appellant must fulfill the provisions which confers the right to appeal. If certain special statutes like Maintenance Compensation Act, Consumer Protection Act, Motor Vehicles Act, etc., it is found that the provisions for filing the legislature provided the power to control in filing an appeal so prescribed, which is manifestly absent in the Railway Claims Tribunal Act 1987. It is also consciously omitted by in case of an these are all central legislations enacted by Parliament. So it's different language in different. So that the Parliament intended that a different result must therefore obtain under the Railway Claims. Therefore, considering all these aspects and the various provisions of the Act, the court is of the opinion that legislature has intended to exclude the provisions of Section 5 of the Regulation Act or to provide power to condone delay in filing the appeal against an award of the Railway Claims Tribunal. First intention of the legislature is not likely to be what is required to be exercised by us exercised in that manner or not at all, and all other modes of performance are necessarily prohibited. Further, it would also be not be proper for the court to direct it.
Okay, there are so many appeals. Now come to this 89 appeal. That is, it may be within the prescribed time and in the prescribed manner appeal to the state appellate tribunal constituted under subsection 2. Who shall that is a refusal of the state or regional transport authority to grant a permit. There are so many in 50 some that is in 89. There is 57 is also been provided. So 57 is any person agreed by the order of the registering authority. Within 30 days of the date on which he has received notice, appeal against the order of the prescribed authority. The appellate authority shall give notice to the appeal to the virginal authority, and after giving an offer to the virginal authority and appellant to be heard in the appeal, pass such order as it thinks fit. There is no condonation of delay application that has been discussed about in 57 also. Yes. Yes. Yes.
Not in the context of the it was in the context of the VAT value advertising. This is the first. The question of law which has some value added tax given after referred to as a VAT Act. Paragraph 4, section VAT Act also prescribes a limitation period of 60 days within which a revision petition is to be referred to the High Court. Since there was a review of 335 conditions, applications under section 5 of the Limitation Act, seeking condemnation. I could have discussed the applications. Can we see minutes on the next page?
Now let us read the provision.
That is extracted at page 6. Each minute there are 2 footnotes. First is minutes section 18, which refers to the appellate tribunal.
79 appeal to the appellate authority.
Section
The appeals to the appellate tribunal.
Yes, appeals to the appellate tribunal. Where minutes like section 17. There is a provision for condemnation of delay, provided that the appellate tribunal may admit an appeal after the expiry of 60 days if it is satisfied that the appellate execution cases. The appellate tribunal can we see revision to the High Court, which is what the Supreme Court is looking at.
Even 79 also there is the same provision.
Yes,
you turn to page 5, appeals to the appellate authority, 79. Where the appellate authority, subsection 2 of section 79 provides that it can be condoned within 180 days. Yes.
Then we have revision to the High Court in the next page.
Yes.
Revision to the High Court, any dealer or other person who is dissatisfied with the decision of the appellate tribunal of commission made within 60 days after being notified of the decision of the appellate tribunal, file a revision to the High Court and the dealer or other person so he shall serve a copy of the question was, there is no provision for condemnation of delay in section 81. The question was therefore whether section 5 of the Limitation Act can be.
What is 84?
84 is application of section 4 and 5 of the Limitation Act 1963. In computing the rate of limitation under this chapter, the provisions of section 4 and 5 of the Limitation Act. The argument for this can be seen paragraph 9.
Yes.
For condemnation, for this purpose, the learning council relied upon section 29(2) of the Limitation Act 1963. These provisions contained in sections 4. Any special or local law where these provisions are not expressly included by such special or local law. In other words, it was argued that in the absence of big provision, in the applicability of section 424, those sections are applicable, which is the argument which is also. Paragraph 14. In Commission of Customs and Central Excise, question that felt for determination was as to whether the High Court had power to control the delay in presentation of reference application under instruments of Central Excise beyond the period prescribed by applying section 5 of the unamended section 35. Section 1 of such reference application. There was no provision to extend the period of limitation beyond this and to control the delay. So the fact that was of delay up to 30 days if sufficient process is sold. But the equivalent in the rated claim cycle act is section 17, where the rate cycle of income delay for the high court. Likewise, appeal to the delays under section thereof, and subsection 5 of section 35 will create power to the definite lender to control the delay irrespective of the number of days that sufficient process shown. Act is analyzed. The categorical opinion of the court in India was that in the absence of any such power, the High Court did not have the power to control the delay. In that case, also, the provisions of Section 29(2) of the Limitation Act was tested to service. This argument was in the following. Specifically provide additional period of 20 days in the case of appeal to the commissioner. It is silent about the number of days. The appellate tribunal, additional period of 90 days in the case of revision by the central government has been. However, in the case of an appeal to the High Court and reference application to the High Court under Section 35H, Parliament has provided only 180 days and no further period for filing an appeal and making reference to the High Court is mentioned in the Act. Then considering the very same question, namely whether the High Court has power to control the delay. Judge bench making another paragraph 16, the meaning of expressly excluded. It doesn't have to be there doesn't have to be a provision in the Limitation Act saying that the provisions of the Limitation Act are excluded. Because the Supreme Court reasons in this manner. Though an argument was raised under paragraph 16, it was contended before us that the words expressly excluded would mean that there must be an express reference within the specific provision the operations to be excluded. In this regard, we have to see the scheme of the special law, which in this case is the Central Excise Act. The nature of the remedy provided is such that the business code by itself is provided by if on an provisions, it is clear that the provisions of the Limitation Act are necessarily excluded, then the benefits contained there cannot be coordinated to supplement the special provisions of the Act. We have considered view that even in a case where the special law does not exclude the provisions, let us be open to the exclude their operation. In other words, the applicability of the provisions of the Limitation Act, not from the Limitation Act, but by the provisions of the Central Excise Act relating to filing of reference application to the High Court. The first judgment in Congo is a complete answer to the arguments of the. It may be relevant to mention that after the judgment in Congo of Section 25 of the Central Excise Act was amended by Parliament, giving power to the High Court to condone the delay by Section 28, which is not the case in case of the efficiency. If it intends to give power to the High Court, Kumde Narayana is celebrating that we will on the same point, which is expected. Examine the provisions of the section to arrive at a conclusion to exclude the operation the apparent legislative intent which can clearly be evinced is to exclude other provisions including section 5 of the Constitution Act. Any specific provision in special law, provision section 5.
That is the reason that it was specifically it was named. Section 4 and 12 will be applicable. So the others were it is specifically yes.
That's in the context of the Regulatory Tribunal Act. By having a completely different mechanism for appeals before the compared to another application before the Regulatory Tribunal. There is a specific provision that is the tribunal to control it. Whereas the absence of a provision that's making the High Court to condone the delay, it's a factor which shows that the legislature did not intend to exercise powers in the decision. That time, however, there is also an overriding provision that says that the act shall have overriding effect. Other legislation stand excluded, including, for example, the CPC. The legislature intended that it is a complete code, and it's also the rationale, the legislative wisdom is that these applications must be because in aid of that legislative aim of expeditious resolution, there is no power in respect of
You concluded? Have you concluded? Chapter 4. Yes.
Every aspect of the issues which arise before the court will have to be considered. As three Marat deals with jurisdiction. Chapter 4 deals with the procedure of the tension. The upright jurisdiction in chapter 5 contains only one section with 3 subsections.
All those sections has been, they have referred. ಇದು ಕರ್ನಾಟಕದ್ದು ಲ್ಯಾಪ್ಟಾಪ್ ಕೊಡಿ. It's a provision for condonation of delay here.
Only if it is inconsistent in error. It is not contradicting any act. This act provides for freedom of limitation. But the Limitation Act under Section 5 gives application to Section 5 of condonation of the no consistency product becomes there is an application of Limitation Act.
MFK, no? What is on the merits?
This track was it has a A, C, and D. Each are the first layer. They find a temperature pattern. They find a temperature pattern. Respect to the fact that we travel to a long approach, they are like ready out. The repetition came to dismiss once you know that they made this request to transfer the work to the long approach. They are going to interpret dismiss. Present this fact, they find a temperature. For the temperature, we are also not ready to the notice of this court statement. The terminal says there's a contract to be so they are going to pay to be the refund. Even the issue is a mistake issue of market this way of
How many days delay?
from the date of
First thing is that he has not brought to the notice of the claim tribunal the case. It was already it has reached finality in the first round before this court. There was suppression of the material facts. So there is some negligence on your part. Not only in yes. Whether it was bona fide, that is yes. And even by filing also, while filing also. Review ಹಾಕಿದ್ರಂತೆ ರಿವ್ಯೂ ಹಾಕಿ ರಿವ್ಯೂನು ಡಿಸ್ಕಸ್ ಆಗಿದೆ ರಿವ್ಯೂ ಆಗ there is a 3 months delay ಇಲ್ಲಾಂದ್ರೆ 1000 days delay. Yes. That is the reason they are strongly harping upon this limitation provision. They make yes, yes. Liberty was reserved to approach the client's tribunal, notwithstanding.
But the fact is, therefore, the tribunal was given they said that we have which requires us to carry the shade for longer. Despite the fact that there is a 500-kilometer road to Passport, we have a rationalization of it which requires us to carry it to a longer route. In fact, they did not carry it to the longer route, they carried it to the shorter route of 500 kilometers. But they said that because we have a rationalization of it, we will still charge you on the basis of the longer route, despite the fact that we've carried it through a short route. This, the railway claims tribunal says, is completely contrary. It is scientifically contract. must be compensated for the service that you provide. If you actually have carried it to the wrong road, you can of course start. But when you have not done so, the rationalization order does not enable you to do so. That's a very detailed judgment. In fact, this is very detailed, articulate judgment. Which will of course take the logic from the rights of the case. But on this aspect of limitation,
so we will list it on by next week, 18. By that time, yes, we can pronounce 17th. Yes. On the day we can pronounce, we can our decision on this limitation aspect. Yes, then we can proceed further. If it warrants.
We have to raise the law for you. This is purely a limitation. Even if there are some activities against it, it's not just that we will take we will look into this further as to whether any of these implement
not only for the railways department, even for the parties who are approaching this court beyond 90 days, whether they are entitled to seek for condonation of delay is also a question that yes. And it has a larger, wider ramification also, because if the doors are closed beyond 90 days, we'll find out and we'll come out with the decision by next week. Point of limitation. And let it be listed on 24th. Yes. Huh? 25th. Yes, let it be on 25th.
May I make submissions?
Yes.
Serial number.
Appeal is not yes. In the meantime, check to records for further arguments. In further arguments there.
May I make submissions? Serial number 35. Kindly have it next week. After some inconvenience.
25. When do you want it?
A date may kindly be fixed, my lords. I am appearing for the respondent, my lords.
Any date.
For matter for here in serial number 25 here.
Please, my lords.
Yes.
Any date may kindly be fixed, my lords.
It has some bearing on this. Let it be listed on 25th. That also. Yes.
Serial number 35. Lords. I'm sorry.
Yes, serial number 35.
Next week, any date.
Rest of the matters are urgent.
I am for the appellant. Next week, any date.
Let it be listed week after next.
Please.
Please.
Week after next we have already. Yes, sir.
ನೋಡಿ ಮೇಡಮ್ ಇದೇನೋ ಬೀಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ತಳಗೆ. ಇಲ್ಲಿ ಐತೆ.
Hello. Hello. Hello.
ಮೇಡಮ್
ಧಾರವಾಡ ಬೆಂಚಿಂದ ನವಾಜ್ ಸಾಹೇಬ್ರ ಜೊತೆ ಈಗ ಡಿಪಿ ಇದೆ ಎಲ್ಲ ಸುಜಾತ ಮೇಡಮ್ದು ಕನೆಕ್ಟ್ ಆಗಿದ್ದೀವಿ. ನವಾಜ್ ಸಾಹೇಬ್ರದ್ದು ಸುಜಾತ ಮೇಡಮ್ ಜೊತೆ ಡಿಪಿ ಇದೆ ಅಲ್ಲ ಸರ್?
ಇದೆ 2:15.
ಅದೇ